Mr. Semenya.
Good morning, Chairperson. Good morning, Member Bena. Chair, we beg leave to call Mr. Vermaak to the witness stand.
Yes.
Mr. Vermaak, good morning.
Good morning, sir.
Please give us your full names.
John Gregory Vermaak.
Do you swear that the evidence you're about to give us will be the truth, nothing else but the truth? And if you do, please raise your right hand and say, "So help me God."
So help me God.
Mr. Vermaak, you have a very long career. You are an attorney, aren't you?
I am indeed.
And you have served in various capacities over the years, haven't you?
I have, sir.
I would like us to, if we may, in a pithy way, discuss your background as a practitioner and as a public official in relation or on matters germane to the bed buildings.
Certainly, sir. Thank you. I'm currently at a firm called Vermaak Marshall Wellbeloved. We specialize in property. I do personally a lot of eviction-related work and have done for a long time. At my previous firm, Moody and Robertson, I did a lot of city council work, and that is where I engaged a great deal between 2001 and possibly 2010 or 11 in the context of bad buildings. So I can't profess expertise, but I can certainly express an opinion with respect to bad buildings and the concept of bad buildings.
Given your experience.
Thank you, yes, sir.
Yes. Now, just again in summary form, what were you doing whilst you were with the city?
From 2001, the city implemented the bad buildings program, in terms of which it emptied many, possibly hundreds, of bad inner city buildings. I did many of those as an attorney at Moody and Robertson, and was involved in extensive litigation, which culminated in the Blue Moonlight matter in the Honorable Constitutional Court.
Yes. And in the context of bad buildings, you are now familiar with the legal instruments that pertain to them, don't you?
I am, thank you.
And in the fullness of time, I will try to traverse with you various sections and instruments and codes in relation to this setting. Might I draw your attention, though, to a statement dated 14th day of October 2024. It bears your signature and name at the bottom. Are you familiar with the document?
I am.
It specifically dealt with the question of the High Point building. Am I correct?
Yes, Mr. Semenya.
And like us and the commission who went to do an inspection in local, we went and investigated in particular also the High Point building.
I did. I represent the owners. I have done for some years. And we conducted an inspection in loco with the Rental Housing Tribunal earlier this year. So I was there. We went to several floors. We went into several flats.
Without going into detail, you share the view, as I see it, with the evidence leaders that the building is not a bad building within the meaning of the bylaw relating to bad buildings.
That is my respectful view. It's not in great condition. There are broken windows. There are broken panels. But I've formed a fairly emphatic view of what constitutes a bad building or a dangerous building. And in my respectful view, A bad building is one where there's a fire danger. I don't believe, for example, that there are very many buildings in inner city Johannesburg that have a structural problem. There are many problems that are largely cosmetic. It's, in my view, all about fire and the ability to escape from the building in the event of fire.
And in respect of this, you don't hold the view that it is one of those, am I right?
I do not, Mr. Semenya.
Yes. And on the same statement, you deal with the question of temporary emergency accommodations, and this is what you say at paragraph 5 of your statement. Not all evictions require TEA, and not all of the above-mentioned buildings are bad buildings, but a number should be counted amongst the worst buildings in Johannesburg. I make particular reference to the bad buildings in Davis Streets and to the matter of Casamia, which is a city-owned building. Open brackets, Casamia is not an eviction application. Instead, it is a mandamus against the city to remedy the conditions of the building as a result of the impact of surrounding properties. I just want your comment around the TEAs.
Thank you, yes. The thrust of that statement was that we have possibly 25 buildings that are subject to eviction applications in our office. A proportion of those are what we would call bad buildings. And I reference particularly the Davey Street matter, which I've expanded upon in my subsequent statement, where evictions are held up indefinitely by the city's inability to provide TEA. Now, again, as I mentioned in the statement, not all evictions require TEA. If someone is fallen into arrears with their rental but are completely capable of paying rental, you know, they don't need alternative accommodation on the part of the state. But it's axiomatic that many of these bad buildings, and the Commission has seen many of those, the occupiers are the poorest of the poor, and they cannot, through their own resources, provide alternative accommodation. So what they will do is they will require temporary emergency accommodation from the state as manifest in the local authority. That's essentially the ruling in Blue Moonlight. Now, the problem is that the provision of TEA is hopelessly poor. I can only remember in the last 5 years one example where TEA was provided. And we are in an ongoing series of litigation with the city, trying to get the city to provide what we regard as constitutionally compliant reports, which would indicate to a court in an eviction application where and when people will be provided with TEA.
Let me solicit your, your views also on the very status of what are called temporary emergency accommodations.
This is a problem in Johannesburg, and respectfully, I assume it's part of the scope of this Honourable Commission. What Johannesburg and other municipalities seem to want to do is to provide buildings that are geared towards TEA. The trouble is, I think that's a luxury. The housing code is clear on what needs to be provided in terms of TEA, and essentially, it is acceptable to put people in impermanent structures of not less than 24 square meters, with the provision of, with close provision of water, with close provision of toilets, be they temporary toilets. So the code permits a certain type of accommodation. The city appears only in extreme emergencies to make use of that type of accommodation. The problem is that there are, if I venture a guess at the numbers, there are 10,000 units of temporary emergency accommodation required in order to proceed with the eviction of, if I've got 25, there must be 100 or more buildings in Johannesburg that need to be emptied. I'm not talking about ones where there's just a non-rent paying eviction. I'm talking about the dangerous buildings, of which there are several. And I've given the example in my subsequent statement of the Davey Street buildings, which in my respectful view are terrible. And living in them is worse than, quite frankly, being on the street. They will potentially kill you.
And just embellish that opinion a little bit more. We are aware of the tension that exists between those who are in these unsafe buildings and by contrast, homelessness. Just try to explain that a little bit more.
Myself and Seri have been in a debate for many, many years, and we mostly agree on what the law is and what the requirements of the municipality and the state are. Where we may differ is in a building such as Davies Street, where there are, well, as I mentioned, the problem with a bad building is the fire danger. Firstly, the danger that there may be a fire more readily than in a well-maintained building. For example, there will be illegal electricity connections. There will be collections of refuse. The structures will be erected inside a building that are made of flammable material. Worse than all of this, though, is the ability to escape. The example I always used to give when I was doing work for the city was, it's 3 a.m, there's no electricity, there's a fire, the place is full of smoke, there are no fire attenuation measures, there's no fire safety lights, there's no guide as to where you are to go in the event of the fire, and you are 5 years old. That is the thing that gives me sleepless nights.
And as you articulated in paragraph 7, you say, the presence of internal structures in a building made often of flammable materials and non-compliant with the National Building Regulations and Standards Act, the presence of illegal electrical connections, or the absence of electricity leading to the use of paraffin and candles for cooking and light are a signifier of danger. Blocked, locked, or broken fire escapes present a serious danger, as does the absence of fire safety lighting, signage, etc., as you just now said. Illegally converted buildings not designed for residential purposes will in no circumstances have compliant fire escape mechanisms. Is that a fair description of what you seek to convey about this?
Absolutely fair, thank you.
Yes. And before we go anywhere else, okay, and then you go on to say in paragraph 8, if I step back, there are 2 primary problems with the city's provision of TEA. The city indicates that they will not be able to provide TEAs for at least 3, 4, or 5 years. And secondly, it is not willing to provide TEA to undocumented foreigners. The obligation to provide TEA to all in the Republic is respectfully tried, but contributes to routinely non-compliant reports on the part of the city in eviction.
One cannot get an eviction order if the judge does not consider the eviction to be just and equitable. In order for an eviction to be just and equitable, in circumstances where somebody is of the poorest demographic, who may not be in a position to provide their own accommodation, the city needs to advise the court where and when people will be provided with accommodation, temporary emergency accommodation. I haven't gone at all into permanent accommodation. Obviously, permanent accommodation is not due to undocumented foreigners. But the premise of TEA is an emergency. And the emergency includes those facing eviction. So what the city don't appear to realize is you can't set a matter down for hearing and request a court to give you an eviction application on the never that in 3 or 4 or 5 years' time, accommodation will be provided, because the judge will have to consider in that eviction application where they are going. Is it just and equitable? Is it fair? Where will it be? What will it, how will it be constituted? So these eviction applications, many of which for terrible buildings, are paralyzed by what we consider to be unconstitutional reports.
And to say against paragraph 11, the housing code is respectfully clear on what TA can comprise, and the city's insistence on inner city building for purposes of TA is misplaced. Until the city recognizes, you say, their faults in this regard, provide a substantial amount of TEA, owners cannot evict bad buildings to the ultimate danger to the occupiers. That's how you conclude your statement.
I endorse that.
Yes. Now, before we move to another aspect, the Whitehall judgment, you are involved in that as you make ample reference to it, the judgment of Judge Mia.
Yes.
Am I right?
You are right.
But of course you accept, as you must, that on a platform like a commission, we cannot deal with the merits of that application.
Of course.
You also would accept that we cannot make comment or variance with the conclusions reached by the court in those.
Of course.
But it is of limited relevance for us insofar as you deal extensively with the legal instruments that are bound to the question of bad buildings.
Yes.
All right. Now, Chair, if there is no objection by any party, I would like to have this initial statement of Mr. Farmak dated 14th day of October 2024 as Exhibit JGV1.
Any objection, Mr. Nyando?
As a chair, please, there are no objections.
Ms. Matumisa?
No objection.
Mr. Mgomezulu?
No objection, Chairperson.
The statement of Mr. John G. Vermaak is admitted into evidence as Exhibit JGV1.
I'm indebted to you, Chair. Mr. Vermaak, you also have another statement you made relevant to the issues before this commission. Am I correct?
Correct, Mr. Semenya.
And that is a statement, just trying to date it 25 October 2025.
Yes, apologies for the late submission.
That's okay. I just want to fleetingly go through with you about it. Now that we recognize the merits and correctness of the judgment is not open for conversation in this commission. You deal with buildings, in particular those that the commission has also which is another building which abuts 38 Davis Street. Am I right?
Yes, yes, sir.
Now, those are of interest to the commission because there seems to be a dovetail between what your experts do and say about them and what the commission's own inspection in loco has revealed. Shall we go just from one to the other? And I invite you to look at three aspects to these buildings. Your application for what it is worth and its merits and findings aside, it was accompanied by expert reports of an architectural nature, those of a structural nature, and other experts. Am I
That's
right?
correct.
To that, you then deal with a whole coterie of provisions in the law relating to bed buildings, don't you?
Correct, yes.
Okay. Now, if you go to page 5 of your statement, you will see against paragraph 11 that you deal with the question of fire safety.
Yes.
I want to suggest to you that the evidence leaders
That is correct.
Usindiso is no different a case study for that proposition you are making.
I
Am
would
right?
believe that, thank you.
Okay. And you say against paragraph 11, the owner's greatest concern and your submission from the owner's perspective is that the occupant statement relating to 32 to 40 Davis Street. Regarding that, your experts' finding in respect of 32 to 40 Davis Street include the following. Can I read them out to you?
Thank you, yes.
In respect of, in quotes, moderate risk, you found that
That is correct. Suffice it to say, apologies. It should be that internal partitions do not have 30 minutes fire resistance.
so the statement will be so corrected.
17.1.2.
Yes, do not have.
I formed the view 20 years ago when I was involved with these bad buildings that even fire countermeasures, extinguishers, hoses, etc., are not the real issue. The real issue is the ability to escape.
Yes. Well, we'll go to the bylaws dealing with the questions of egress. to these buildings in the event of an emergency involving fire.
Thank you.
Okay. Now say your expert in relation to moderate fire risks and concludes the buildings are not fit for residential occupation and the lives of the occupiers are in danger should a fire occur. Continues to say the non-compliance with basic fire protection measures as provided for in the National Building Regulations renders this building unsafe and a high fire risk. The absence of an evacuation plan, evacuation procedures, and assembly areas mean that the evacuation of the buildings in case of emergency will not take place in an orderly fashion and ensure that all occupiers are accounted for. The fire safety also provided a fire compliance photo report. Now there are a whole host of attachments to your statement indicating and depicting the nature of fire hazards that are in the building. I will not go to them immediately or necessarily in sequence, but we'll deal with them globally. But what they do show is that the staircases are inaccessible, the staircases are without handrails, the fire hose reel is without water, the walls within the building are combustible, the fire hose reel is not connected, the absence of firewall also have another expert, which is the findings of an architect.
So forgive me. The next two experts were in fact proffered by the occupiers, by Seri on behalf of the occupiers. We submitted the fire safety report. The architect and the structural engineer were provided by Seri in response to our application.
About which you don't take issue, I take it.
No, I don't.
And there should be common cause with what is said there as well as what Seri has filed in that regard.
Very much so.
It might not be necessary then to deal with those reports of the two experts, which are common cause, and the commission will consider them in that light.
Thank you.
Yes. You then deal with your conclusion against paragraph 38 of your statement. You'll find it at page 20 of the document. So say you, in light of the findings of the fire safety expert, the architect and engineer, it is beyond dispute that the properties are unfit for human habitation. And to deal with Chapter 7 of the Constitution, You deal with section 151.3, which we all know governs the jurisdiction of municipalities. And you deal with 156 as well, 156, Schedule 4, Part A to the Constitution, and Section 195 regarding public administration, Section 237, which enjoins constitutional obligations to be performed diligently and without delay. You do, right?
Correct.
But you also reference the Housing Act of 107 of 1997 and the local government, what is called the Municipal Systems Act.
Correct.
You deal with those and refer to 156.4 of the Constitution, am I right?
Correct, yes.
And as I say, you then deal with Section 82.11.3 and other Section 4142J of the Systems Act relating to the obligations of a municipality, am I right?
Correct, yes.
Over the page, you deal with Section 9.1 of the Housing Act, which obliges the city to take all reasonable and necessary steps within the framework of national and provincial housing legislation to ensure, amongst others, that inhabitants of its area of jurisdiction have access to adequate housing on a progressive basis, right? And you also reference the housing code, the National Housing Code. It is important to emphasize from your statement what that code in summary entails about the provision of adequate housing. Can you give us in your own words?
In the event of temporary emergency accommodation, the provider of TEA, I would try and find the particular area, has to provide an accommodation of not less than 24 square meters. It can be made of impermanent materials. As I mentioned earlier, it has to have access to water. It has to have access to toilets. There is a preference that it not be too far from the eviction site, but there isn't a requirement. In general terms, we interpret that as within the relevant municipality.
And Section 2.3.1 of the code deals with emergency situations, and you deal with that against paragraph 63 of your statement.
Correct.
That emergency includes, in quotes, living conditions that pose
application by a third-party owner. This obligation vests in the municipality notwithstanding. We've launched our first application in recent weeks to this end against the city of Joburg without bringing an eviction application to require the COJ to fulfill this obligation. They have given indication of the intention to oppose it, but I'm hoping that's in anticipation of a settlement discussion.
All right. And to then say these buildings, i.e. those on Davis Street and Sherwell, are typically those that constitute an emergency. Is that right?
That is our belief.
And you say section 2.6.1 of the code is triggered and obliges the city, amongst others, to initiate
The city must have a plan to deal with bad buildings. Respectfully, it's our view that this plan cannot be idealistic, and it cannot be 3, 4, or 5 years in the future. It has to be a plan that is usable immediately, because there are people residing in buildings right now that are far too dangerous for them to occupy. So this accords with the legislation. This accords with our view of the obligation of the state as manifest in the city.
Yes. And to significantly point out against paragraph 72 on page 28 of your statement that the housing code does not prescribe because there naturally appears to be a tendency from those to be resettled to be as close to the buildings in which they are.
This is a debate that I've had with my colleagues from SERI for more than 20 years now. The problem is that frequently the poor occupiers of these dangerous buildings live by informal means. Often those informal means are waste picking, waste recovery, odd jobs, piece jobs in the city. The city of Joburg, here it is, it's massive. There are hundreds of thousands of people in and out it every day. It provides work opportunities for the people who live in these buildings. The problem being, of course, that living in the inner city is desirable for those people because the cost of transport is so high. I've encountered buildings where people live on 80 divans in an open hall at 10 Rand a night because it's cheaper than taking a taxi home every night. So this is and unfortunately we've also seen people sleeping on the pavement, working people who would rather save the money than that they would otherwise spend on transport. So I understand the debate. The problem is, and this is where I may differ with my friends from SERI, is the inner city can't become a hostel for the very poor. There has to be a way, a place that the city can identify for temporary emergency accommodation, which doesn't have the impact of eroding what I respectfully regard as the rates base provided by the historic inner city of Johannesburg. To me, these buildings in town should be occupied by formal business, paying rates, paying rent, paying tax, using that money to support the poor, who, in my respectful view, shouldn't be living necessarily in brick and mortar buildings in Johannesburg. Part of the problem is the plan of the city to use inner city buildings is if you have a bad building, it takes 3 other buildings to compliantly house the occupiers of that building. The numbers don't add up to me. So let's say Casimir. Let's say you're going to empty Casimir to use for temporary emergency accommodation or accommodation of any sort. To empty Casimir, you will need 2.5 or 3 Casimir buildings. I don't understand the logic, to be frank. What has to be provided is accommodation at scale. We know what TEA comprises, wherever the city can. I've always thought respectfully that the old mining land east of the city would be appropriate. But again, my view is if it can only be provided further out, then that must be done. People cannot remain in these buildings.
TEAs, are they ever temporary?
No, they're not. That is an intractable problem, and I don't have an answer for it.
Yeah, it becomes intractable because
people never leave them.
they never do. And should they be in brick and mortar?
They're they're very compelling to stay in. There's a problem that I must identify. The city has long, and this is where I agree with my friends from SERI, the city has long taken the line that people can graduate from temporary emergency accommodation. In other words, you can go into TEA for 6 months or a year, you'll receive training, you will get the ability to earn your own living and, in inverted commas, graduate from TEA. But I think that's a flawed system. And I don't think the courts have smiled on that view. After Blue Moonlight, there was a follow-up in the Constitutional Court known as the Dladla matter, where the city's managed care model was quite solidly criticized. I don't know what the answer is, and I know that part of a substantial part of the problem is, of course, apartheid legacy, where people want to take their state-subsidized house in the rural areas and then live in Johannesburg as cheaply as they can and remit to the rural areas. And I mean, it's not everybody, but there are tens, maybe hundreds of thousands of people who take that view. And I respectfully regard that as part of the problem of shack proliferation, part of the problem of people wanting to live as cheaply as they can in Johannesburg, not take their subsidized house in Johannesburg because they want to take it in the countryside somewhere. So that to me is a serious problem, and one of the reasons why TEA seems to turn into permanent accommodation. That seems to have been the case. In the reports we get, it appears that all of the city facilities are full and out of control, which to me also suggests the rationality of less formal structures not taking and utilizing brick and mortar buildings in the inner city of Johannesburg for TEA.
Is there a prescribed radius within which a TEA must be erected for resettlement of those who are moved out of the bed buildings?
No, there's not.
Now, anecdotal evidence suggests to us that the people who live in these bed buildings, some of them do pay rent.
No one lives for free anywhere in Johannesburg, probably in South Africa. We hear this anecdotally as well. Let me say again, that our friends from SERI are very good at ensuring that the people they represent are not hijackers. They are not people that are collecting rental and trying to use the system to protect their cash flow. But in the normal course, we hear the stories of Usindiso. I don't know the story in Whitewall. We are told that there is no rental collection there. And if I know SERI, they will have advised their clients in the strongest terms that they are neither to collect rent or pay rent. But in general terms, as a general rule, there's always rent being collected. And I mean, again, colloquially, I've also heard the stories for going on 30 years. There's always an enforcer, sometimes a rent-a-cop policeman that comes around late at night, collects rental. The evictions for non-rent paying are certainly not done in terms of the Constitution. So, yeah, I don't have specific examples I can give off the cuff, but that is certainly our colloquial experience as well.
Another thorny point relates to the city's obligations in relation to undocumented nationals in the event of emergency.
Very thorny point, and we're in the process of litigating that point as well. The problem prior to 2021, the city would investigate and report on everybody in a building. From about March 2021, the city started taking the line that it would not and could not investigate undocumented foreigners. This is the problem of the Department of Home Affairs. The problem is, again, in our experience, Home Affairs have one tool. They arrive at the building with police. They kick down a door or two, they take away a few heads of household, they leave everybody else, and within a few days, the heads of household are back because Lindela is full. So the Department of Home Affairs mechanism is not fit for purpose. The problem is, it's the city obligation to report to the court. It's the city, if it believes that it needs to engage with the Department of Home Affairs, it must do so. And it must get Home Affairs to assist it in preparing a report, which says to a court, in this building there are 40 flats, 29 of them are occupied by undocumented foreigners, the 11 occupied by South African citizens. These are their circumstances. 5 of them can look after their own alternative accommodation. 6 of them will require the assistance of the municipality. Home Affairs will say 29 flats are occupied by undocumented foreigners. This is what Home Affairs proposes to do with respect to those individuals, whatever it may be. Be it regularizing their occupation of South Africa or deporting them. That will be their business. And then the city must say, of the people that require temporary emergency accommodation, we can provide TEA at such and such a place on such and such a time. I've always taken the view, respectfully, but hopefully not too self-servingly, in Blue Moonlight, the Constitutional Court gave the city 6 months to resolve the temporary emergency accommodation issue. And we are aware, and my clients are aware, that they have to be patient in the context of the provision of TEA. They have to endure the state's obligation for some months at least. And in my respectful view, that time is 6 months, but not 3, 4, or 5 years or more, where a private landowner has to fulfill the obligation of the state in providing temporary emergency accommodation. So the Home Affairs issue has become a serious problem. Home Affairs do not engage. It's very difficult to make contact with anybody at Home Affairs that will engage with you. And it's our respectful view that it's the municipality's job to engage with Home Affairs, incorporate their findings into a report, provide a constitutionally compliant report to the court, including a report on the potential fate and dispersal of undocumented foreigners.
Chair, may this be a convenient time? I intend to move to another sub-element of the statement after tea.
Yes, we'll adjourn for tea for about 15 minutes. Mr. Vermaak, you are reminded that you are still under your former oath.
Thank you, my lady.
Again, anecdotal evidence tells us that the city officials would arrive at no, not city officials, officials from City Power would arrive at a building to disconnect electricity, only to illegally connect it hours later for the same building tenants. Are you aware of that at all?
I've heard of that many times, Mr. Semenya. Unfortunately, if I may expand, the city cuts off water and electricity in the face of queries, even in the face of court orders, routinely. We are involved with extensive litigation on that point. So that is with formal corporate owners who have raised a query, even taken a court order, but the city will come along and cut them off. What often happens, unfortunately, especially on a Friday, especially leading up to Christmas, is I think sometimes the cut-off people go on a money-winning frolic of their own and arrive, demand a couple of $1,000, otherwise they will cut off. So the problem is twofold. Firstly, in a conventional building where people aren't paying rent, they will be able to obtain an illegal connection. In a functioning building, people are paying rent to the owner, who is in turn paying it to the city, but for a queried amount or possibly even an amount subject to a court order. But then there's a cutoff, invariably on a Friday, and that has an impact on the relationship between the owner and the tenants. And I've seen in my own experience, on at least half a dozen occasions, that has then spun off into a rental boycott because people believe they're paying for services. The owner is keeping the money and not paying it over to the city, which isn't the case.
You then deal with the National Building Regulations and Building Standards Act. I don't think those provoke any controversy, but the enforcement of the building regulations is the responsibility of the city, am I right?
Correct.
You deal with various sections of that statute and then get to say, in respect of fire, that is paragraph 100 of your statement, the regulations provide that any wall shall have combustibility and fire resistance characteristics appropriate properties bylaws. You reference the Constitution, the Systems Act, and Code Section 1 of the problem properties bylaws, which has the following relevant definitions. Regarding building, it means any structure, whether of a temporary or permanent nature, and irrespective of the materials used in the erection thereof, erected or used for or in connection with the a property declared a problem building?
I have to say that I know very little about the problem buildings bylaws. I've never enforced them. We've barely used them. We've quoted what would hopefully be useful to the commission, but I do not have personal experience of giving effect to the bylaw. May I mention though that the problem with notices is it becomes a circular argument. A notice is issued to the owner. The owner can't fix the problem without evicting the building. The owner then can't evict the building without the provision of TEA. So unfortunately, you find the circular argument. So again, the solution to me to all of these problems is the ability to empty a building. And at the moment, there isn't an ability. You know, obviously the poorer demographic and bad buildings are unfortunately synonymous. They're not. I was discussing with colleagues in the tea break. Many of these buildings go back. Let me start again. In the early 90s, there was what they called capital flight from the inner city. By 2001, 10 years later, there were many abandoned buildings in Johannesburg. We're not talking, we really aren't talking much about the conventional eviction, the conventional hijack we hear of. There's not, there aren't many hijackings nowadays. That was a function of the late 90s and the early 2000s. What we are dealing with are buildings that were probably occupied in that period after 1991, when capital flight was rampant. So if I may, again, and if I may say, I gave extensive examples of the White Wall building, of the Davey Street building, not by way of criticizing the court or anything like that, but by way of giving a factual example of what we deal with. And the problem, let's say in that matter, is the city opposed the application. Even SERI opposed the application, and it failed, which surprised me. So with Usindiso, with these Davey Street buildings, they are all old commercial buildings that have been illegally converted. And the building regulations are very clear. You can't, you'd have to have a new right of occupancy of a commercial building if you converted it for residential purposes. And there's some very basic truths. A residential building, the fire escapes are twice the width of a commercial building. And the reason is commercial buildings are occupied in the day by adult people, whereas a residential building, I mentioned the 5-year-old earlier on, and they're asleep, and it's dark, and they're potentially children. And you cannot occupy, you cannot and you should not occupy an illegally converted commercial building. And that, to me, all of these regulations, all of these bylaws have survived more than 25 years of constitutional scrutiny. They are solid, and they should be applied. And if I may just reiterate again, the problem is the circular problem. The city will inspect, the city will give a notice, but the only way to fix the problem is to empty the building. Only way to empty the building is in the event of the provision of TEA.
Yeah, so the saying goes, the elephant in the room is this. The contraventions of the bylaws are committed by the city who makes them, who should police them, and who doesn't.
I'm afraid so.
Who should be bailing the cat here?
That's quite right.
Who should bail the cat, in your view? What should
Builder?
happen?
Sorry,
Who should bail the cat? Who must tell the city to do its work and hope that the work will get done?
That's what we need to do. That's what I'm hoping the Commission will address.
Your ideas?
My ideas,
Mm-hmm.
and I've canvassed this with city officials, and I don't have to pay for this, other than through rates maybe, is there are many kilometers of old mining land east of Johannesburg. If you drive east along the M2 motorway, on the left, low-rise buildings, and they're low-rise buildings because there's undermining, et cetera, and I've often thought, I believe it was done in Alex, I believe in the 3-story walk-up option of what amounts to RDP housing. What they also did in Alex, which thought was a brilliant idea, was each RDP unit had 2 rooms, 2 extra rooms, which could be used to rent out to people seeking rental accommodation by the owner of the RDP unit. So to me, 3-story walk-ups, you don't need lifts. You have an extra 2 rooms on each one for rental, and because it's just east of town, east of the city centre, it's not far. Transport isn't an issue. In an ideal world, if I had all the money and if I had a magic wand, that's what I would do.
Yeah, the commission will hear the evidence of the architect as to what may be plausible resolution of architectural designs for the purposes of social housing. Your
Sorry,
statement.
may I address that? I'm so
Yes.
sorry. Forgive me.
Yes.
One of the city frequently relies on JOSHCO, which is social housing. The problem is the people that we are dealing with in bad buildings do not qualify for social housing. You need an ability to pay rent. Social housing requires, I think it's 30% of total family monthly income, which means, in turn, probably a family income of 3,500 Rand per month. And unfortunately, many of the people we're dealing with do not have that level of income. So social housing is not a cure for the problem in the inner city.
Yes. The rest of your statement then deals with what you and I agreed, relates to an application that demands no comment by the commission, which I take it you would not mind if excised for the purposes of the hearing of this commission.
I don't mind at all. Again, I apologize if that was awkward. The purpose was not to deal with the litigation. The purpose was more, here is a terrible building. We try and get it empty. This is a 2011 case number. Our owner believes, the owners believe, and we believe, that it is unsafe for accommodation. If I tell you, after the Usindiso fire, the 2 owners came to see me. They were in tears because they didn't want people to die in a building that they owned. You know, the city in their papers, oh, it's commercial, it's cynical. It wasn't. It was 2 middle-aged guys who did not want a death on their watch. So the point was to illustrate, notwithstanding the danger, respectfully the obvious danger, the city opposed it and Seri opposed it. They were both wrong to do so, in my view.
Chair, with the appropriate reduction of those elements of the statement, and there being no objection to have this statement for record purposes be captured into the archives of the work of this commission, may I request and move that the statement duly redacted be admitted into evidence and marked GV2.
Mr. Mnyandu?
Madam Chair, we have no objection to either the redaction of certain parts of the statement, nor for the embellished statement being admitted as an exhibit in the record.
Thank you.
Madam Chair, I might as well take this opportunity to clarify that we won't have any questions of clarity for the witness.
Okay,
Thank you.
thank you. Ms. Matumise?
Good morning, Madam Chair. There's no objection to the two statements as prescribed to be admitted. I also indicate, Madam Chair, that we have got one question of clarity. We'll take it later, or you want me
Yes.
to?
No, you'll take it later.
Thank you, Madam Chair.
Mr. Mgomezulu?
Thank you, Chairperson. No objection to the statement being admitted.
Thank you.
Thank you.
The statement of Mr. Vermaak as duly redacted is admitted into evidence as Exhibit JGV2.
I would surmise Human Rights has no objection as well.
Oh, it's human rights here. Sorry, I missed you, my dear. What's your surname again?
Madam Chair, Sitole.
Sitole. Yes,
Yes.
Ms. Sitole.
The Commission has no objection to the admission of the statement.
Thank you, Ms. Sitole.
Thank you.
Yes, Mr. Siminya.
May the witness be excused, Chair.
No, before the witness is excused, Ms. Matumise, you wanted to pose questions of clarity to the witness?
Thank you, Madam Chair. That's correct. Mr. Vermaak, just clarity on High Point. You indicated that the tribunal conducted an inspection a month ago, and
Yes.
you are awaiting a report.
Yes.
Just to clarify, is it a report or a ruling of the tribunal?
It's a report in anticipation of a ruling, ma'am. It was a little longer than a month ago. There was a complaint from occupiers about the condition of the building, particularly that the lifts were not working, et cetera, et cetera. It resulted in a hearing followed by an inspection in loco, and the tribunal itself is waiting for its report.
Thank you. Thank you,
Thank
Madam Chair.
Thank you, Ms. Matumise. Mr. Mgomezulu, do you have any questions of clarity to put to the witness?
Thank you, Chairperson. No question of clarity.
Thank you.
Thank you.
Mr. Vermaak, you are excused as a witness. We thank you for having availed yourself to give evidence before this commission.
It's a great pleasure. Thank you
Thank
very
you.
much.
Chair, we propose to call Mr. Aramu Lamula. May we just ask for a short stand down to prepare him for his evidence?
Yes.
We will intimate when you are ready, Chair.
Yes. Will adjourn.
Chair and Madam Commissioner, we beg leave to call Mr. Lamula to the witness stand. Oh, sorry, that chair there. Good afternoon to you, sir.
Afternoon.
Can you please give us your full names?
My name is Solomon Ramaramura.
Do you swear the evidence you're about to give us will be the truth, nothing else but the truth? And if you do, please raise your right hand and say, "So help me God."
Help me, God.
Okay. I'm correct to describe you as the managing director of Take Shape Property Management Company,
Correct.
and otherwise known as the Remington Building. That is under your portfolio.
Correct.
Now, you give us the brief history of Remington, and you say it's a property managed company and a member of the Property Owners and Association, JPOMA, right?
Correct.
And you say Nulan Investment bought the property in 2013 from a private company, right?
Correct.
And it was originally an office building that had been hijacked. Am I right?
Correct.
There has been reference of your name around your work in the inner city environment. Tell us a little bit about your association with JPOMA.
Take Shape Property Management is the management company. We are managing just over 100 buildings. Most of our properties are in the inner city of Johannesburg. And on that, way back there was an association called JPOMA, which was formed by the property owners. And the intention or the reason why we formed that JPOMA was to make sure that when we experience any challenges, especially with the city of Joburg, we can be lodge the complaint together as an association.
All right. But you describe this Remington building being a hijacked building in the past. Explain that a little bit more.
Okay, Remington building was bought way back 2013 by the company called Nulane Investments, and the intention was to convert the building to residential property, where the property will then be fully compliances and able to rent it to the South African citizen. However, since 2013, after the purchasing of this property under Nulane Investment, the property was hijacked. Hijacked is when tenants are no longer paying the landlord or the management the rental, and they actually controlling the building by themselves, where Remington Heights, they even went where they end up appointing their own security to be at the reception of the building, so that us as landlord or management, if we want to walk in, so those security won't allow us to walk in, or either they will be able to threaten us. So since then, obviously, we had to follow the law to apply for an eviction order, which was a very long process.
Yeah, before we get to that, what triggers these hijackings, you seem to say, would in other instances be a result of a dispute about ownership of the property, right?
Yes, correct. So as I've explained here on my evidence, is that always one of the issue that actually caused the building to be hijacked. What we have experienced lately now, what is happening, is when the city terminate the services, like level 3 termination, where there is no electricity in the property, or either there is no water in the property. So what we have experienced is that you find that those tenants, they are able to start trying to arrange themselves or make ways or means of them able to get electricity into those, to that property. And it's always in the illegal way for them to end up having electricity or even having the water in the property. And once that happens, tenant, they don't see any need to continue paying the rent, because they believe that when they pay the rent, they are paying to get those kind of services as well. So that immediately when it happened, obviously the building, it's automatically hijacked, because you're not gonna able to collect the rent where there is no electricity or where there is no water in the property.
Right. And when you started these proceedings, you did make contact with the municipality or the city?
Correct.
And you actually say in your statement you made requests for the termination of these services, which took time for the city to effect.
Yes. What previously we were just engaging with the city. Not actually we wanted the city to come and immediately and terminate the service, because from our side we know that once there is no water, there is no electricity, then that building is not suitable anymore for the people to live in that property. But what we were looking for was to say, because we know our city will continue billing, though as landlord or as owner, while we're not getting any income from the property. Therefore, it's very important to inform the city that this is the situation. If the city have any other way where they can either hold the billing, then it's what we wanted the city to do. Not general to say, go and remove everything there in the property, because we know that immediately after they've done that, then that building is gone. So it was more to get the city to say, look, we're not going to be accountable or responsible for this billing. We accept that we are the owners of the property, but because there is no income, the building is hijacked. We had court proceeding which keep postponing and also get defended, which the city also are part of. Therefore, we would like them to hold the billing, which they didn't do that at all. They went on their own time to disconnect the service to level 3 cutoff.
Yeah, no, I understand what your evidence is. It's that whilst all these disputes are on and off, the clock is ticking in relation to your billing.
Yes.
And it keeps getting higher in respect of a property to which you receive no contribution by way of rental.
Yes.
Okay. And then you tell us in paragraph 8 of your statement that when the municipality terminated the water supply, some occupiers began using fire hydrants for water. Some tenants had started subletting their units to foreigners and collecting rent from them. Is that right?
Correct.
And thereafter, the occupiers afterwards then vandalized and stripped the building.
Correct.
What would this stripping include?
That include all the wiring that in the property, started from the lift, motor room, the LT room for the city of Johannesburg was completely stripped. The lights on the passage was also stripped, including those fire hose rail, the pipes, they were also stripped.
Then you got a court order from the court evicting the occupiers. Statement. Correct?
Correct?
And you say occupiers who could afford rental elsewhere vacated before the TEA was made available. Is that what happened?
Yes, correct. Maybe just to explain there is that 2023, actually from 2022, some of the tenants started to engage with us as management, where it was now becoming easier for us even to engage with them. And we were now planning, working with them to say, look, instead of waiting for the eviction where you will find yourself on the street or without alternative accommodation, we do have alternative accommodation if you do qualify where it's reasonable, because we're looking at 1.5. So there were some of the tenants who qualified and able to apply, but most of them, because they were undocumented immigrants, they couldn't able to qualify. As I said, most of the people who was now remaining in the property was more of foreigners, because what happened, what we believe is that most of the South African, immediately when they noticed that there is no hope in the property is unsafe, there is no water, there is no fire, they have to get the water on the street, they started, instead of just moving out completely, but they started to sublet, where now you bring someone to your room and that person, you go and collect 300-400 rand. That is what was happening at Remington Heights.
And then you saw the intervention of the South African Police Service.
Correct.
And some did move, some didn't, some in fact were sleeping on the pavement outside, you say?
Correct.
In paragraph 11, you say, we have informed the occupiers that we have affordable
The Urban Housing Finance Corporation.
Oh, there you go. They provided 25 million. As you do in your statement with regards to the challenges faced by the city, faced by the developers in the city. Just tell us a little bit more about what you're saying there.
As I explained at the beginning to say, we believe that the hijacking of the property in the inner city is contributed by the municipality. Because they knew how the property looked like before that. But suddenly, after we've submitted all the plans, we got a plan approved. The property is still incomplete because we're hoping to finish the project end of November, targeting next year early to start letting it. They have now changed the value of the property to 40 million rand. I've attached that statement as well. And now the debt, now is the debt that happened during the time when the property was hijacked. Even now for the 1 year that we've been in control of the property, is now sitting at 8 million rand. Now, as a developer, it's becoming now difficult for us to, even after we are spending so much, to the extent where we even contributing to the precinct. As I said, there is over 300,000 rand that we spend just to improve the paving around the area, which is supposed to be part of the municipality. But we knew that our development won't be attractive if we also don't do the street pavement, including the camera. If you come around in that corner, you will see that there is also a caravan trailer with the police that we contributed. So the police are posted in that corner every day just to make sure the area becoming safe. So now with this 8 million on top, which we already tried to engage with municipality to say, look, we're not gonna able to cover the debt during the time when the building was hijacked, but there seems to be no one had the authority to make that decision. So the debt has been growing because this debt now is the new value of 40 million, which we believe that, yes, after the development, that property will actually worth around there because we believe that they actually valued at cost. No one from municipality who came to the side and actually do a proper valuation. But we believe that they value at cost because when we submit plans or whatever, we also submit the estimation cost of how much we're going to spend. And indeed, was this 40 million. And suddenly now, on the statement, we found how everything has changed. Gone up to 33,000 rand per month. So that is the challenge that we're facing. So
Yes.
we even make it an example to say it now, what is going to happen is that we had a plan to say since 2025 early, we will be start letting that property. And that is where you will find now municipality coming and say, this is what you owe because it's now occupied, and you find that a service get terminated and we sit with the same problem.
So for the record, this building is organized to be a student accommodation building, am I right?
Correct.
And if I understand, the complaint is that it is common knowledge between you as the developer and the city that between the hijack status of this building and until the development starts, there is no income generation for that period.
Correct.
And the second complexion to your complaint is that yet the city rates and taxes keep rising during that period of time.
Correct.
And there is no appreciation by the city that there should be some measure of understanding in relation to how you impair the amount incurred during the non-income period of the project, right?
Correct.
Now, the other dimension and complexion to the complaint is that whereas the valuation of the building at its state of disrepair is sitting like 18 million, once the plans are submitted and the expected expenditure on the property is indicated, it then jumps to 40 million,
Correct.
with a corresponding increase in the use rights of that building to impact on the payment of the rates and taxes. Am I right?
Yes, correct.
Okay. Then you said you attempted to reduce the debt with the municipality, indicating to it that the property was what should happen next?
We lately, because as JPAM, I mean, we've been trying to engage with the city to find a way of how best they can able to assist us instead of taking the city to court as we do always in many cases to get our issue resolved. But I can just say, I'm just happy that the meeting that we had, but it's with the city power. It's where they have agreed now to dedicate a team of where we as JPAMA will able to lodge our complaint, to get our complaint to resolve on time instead of going up and down to court, because that also take a very long. So with regard to this one, I'm not sure. So far, we're just hoping that because we have lodged that complaint and we have references, we also lodged the complaint of estimation, because as I said, it's a new, it's completely new, redone. I think it looked as one of the best building now in the inner city. Estimation are coming. I mean, even in this statement, estimation of water, 126,000. There is nobody in the building. The building is still under construction. So these are issues that we must deal with to get that statement corrected.
Yes, and I should have taken it more with Ms. Rivers, who is the top member of JPAMA, am I right?
Yes, correct.
That, and I'm asking you now, what would be your response if the evidence leaders were to recommend to the commission that a dispute resolution platform be created for this type of disputes, so that they can be expedited, they can be identified, they can be filed, they can be resolved within a speedier time frame?
We'll definitely be glad with that. We'll actually be happy because it will resolve a lot of issue. I did mention here on my affidavit that we, as property management company that are managing properties, especially in the CBD, we have formed a department called the utility department, because you cannot survive without having that department, specifically for someone just to look at what the municipality is billing versus your recoveries, to make sure that also to lodge those complaints when they comes. And also to deal with estimation, where estimation according to bylaw of the city is not supposed to pass 3 months, but sometimes it's passing 3 months, and where sometimes they don't even have record of where they've removed the meters of water or electricity, you're still getting estimation. So So definitely, it's something that we have been fighting for, and we hope it can be done for the inner city of Joburg.
And you say the rates and taxes for Remington are now sitting at 40,000 rand a month before you even have one tenant in.
Yes, correct. It's now on this statement. It's it's 30.
Paragraph 16 of your
Yeah, it's
statement.
There is rates account there, so it's 33,000.
No, don't worry.
37, sorry, 37.
Don't worry, we'll go through those annexures to your statement. But the point I think you're making is also that a resolution of this type of disputes, the municipality or the city would require the complainant to pay 50% of what is alleged to be owed before resolution is possible.
Look, on that one, we don't know what is right anymore, because we as developers, sometimes we meet with very senior staff of the city of Joburg. They will explain their processes of how things has to be done, even in case if you want to sign an acknowledgement of debt. But when our staff walk into that office, everything change. I mean, the municipality can advertise to say, come forward with 10% deposit, sign an acknowledgement of debt, get 36 months to pay whatever that is outstanding. Then you want to go and do that, then you hear, no, we don't accept 10%, we want 30%, or we want 50%. So we don't even know. I even think that they must have a screen that shows what is happening, because of the corruption that is also happening there. It's like whoever is helping you, he's got that power to decide whether you want to offer you acknowledgement of debt or not. So we believe that that's supposed to be more to the public, and
So-
without any other condition attached. Because there's that condition to say, for them to consider that, you must bring your financial, your audited financial, which sometimes we submit that without getting an answer. You must bring the bank statement and all those sort of things. So, which sometimes they don't even look at that.
Yeah, and as you say, one of the problems with the whole process is a lack of transparency. You say there should be more transparency, and this might address corruption issues as well.
Correct.
And that can lend itself to this conciliation processes of resolving differences between the city and the developers and our owners. Is that right?
Correct.
And then you deal with under paragraph 17, you say we have litigation with the city for two
association called JPAMA, so we do talk among ourselves, and if we're busy developing, like when we were busy at Mabonin and all that, then you find that you have submitted yours, but you're not getting the approval, or you're not getting the response on time. But there is someone who will tell, no, I just submitted, I've got mine approved, or maybe you must go and see this person. Angela was going to clarify that where we now have to go to the individual to get assistance, you know, and beg for assistance. So that is the challenge, which we believe that the municipality must have maybe some sort of standard rules that it's on public to know that if we submit the plan today, we know that within 20 days or 30 days or 6 months, that plan should be already approved. And if not, here is the process that we need to follow to make sure that it get approved, instead of where now we have to approach individuals that work for municipality.
And you say the city neglects to enforce its
You know, it's what is happening, especially right in the inner city, where maybe I will just start by the parking on the street in the inner city, where now cars are fixed right on the front of our building, in the street car, buses are washed in the middle of the street. So that's why I'm saying they are not enforcing any bylaw, especially in the inner city of Joburg.
Mm-hmm. And you say funding from state entities.
That's what I'm trying to say there. I was referring to the city. It's actually also contributing to chasing the funders that can also turn this city into its glory time. Because of not enforcing the bylaw, then we already faced challenge with the insurance companies that they now wanted to run away to insure our property in the inner city, or it become more expensive now to insure the property in the inner city because of the bylaw as well, and also the building that are not complying. Because you can have your building that is fully complying, but you get your next door building that is not complying. So you have that challenge, because if the next door building catch the fire, it might happen that it also catch your building. So it's about that, and I was referring to this National Housing Finance, which are part of the government, that also it's a process to get the funding from them. So that is what I was trying to explain.
Mm-hmm. And then you deal with what you say are solutions from paragraph 21 of your statement, which reads terminating services And you say instead of terminating municipal services, the city must consider inappropriate circumstances attaching and auctioning. Please do.
Yeah, here I'm trying to say it. If the city go out there and terminate the electricity or water, but still expecting people or tenants to continue living in that property, really it's very clear that that building is no longer complying. And that is what we're trying to say here, to say instead of them running after removing electricity connection and water, is no other way for the city, because we're not condoning us or owners not to pay the city. We know we need to pay for those cities. There is no other way that the city can try to put in place where they can able to take action against the landlord to, instead of running after, because this, we're talking about high-rise building here, where if there is no electricity, these people are going to make other means. These are the people who come from the village where they can make many means for them to make fire, to get water. And whatever that they're going to do in that high-rise building, we must definitely know that it's not complying. It immediately affects the compliance of the building. So we're saying the city need to look at the other means, especially if it's a residential properties, to say, look, if we terminate the electricity for this property, but we still allowing those people to remain in that property, what is going to happen next is the same thing that we have witnessed in the inner city, where the building are catching fire because the people are using candle, paraffin, gas, and automatically that is what is going to happen. We have many properties already in the inner city of Joburg, even Hillbrow, that even now people are staying without those two services. Because remember, when there is no electricity in other properties, the pump, the water pressure is not enough to push the water up to supply the building. So immediately those people got no water. So what they do, they go right on the street, they cut the pipe, whatever, and to try to get, they use 20 liter to get water from the street. So we're saying to say, if they want to completely stop what is happening now, where buildings are always getting on fire, they must find a way of how best they can deal with the landlord that are owing, or buildings that are owing the city, either through to auction it, get to whoever developer, because they're not gonna able to supply temporary accommodation immediately, or to follow up to make sure that because this owner is not complying and we've terminated the services, maybe we must close down the building. But it's what they always said. So I've attached here the statement that was done by Public Safety Committee of City of Joburg, where they explained those
We'll
things.
get to that, yeah.
Yes.
Okay. I was going to say that attached to your statement are various annexures, the first being that which is on the Joburg City stamped there with copy text invoice. Can you tell us what this document is?
Issue in respect of the municipality service charge reflecting areas over 30 days. But on the other hand, we have lodged the query and disputing the amount, but you can see there. And then you look at the second page of that. To the development, but we have to apply everything to get new connection to be done in the property, which is now being done.
And these are the type of disputes you say may lend themselves to to this dispute resolution platform that the commission can recommend.
Correct, because that it become very clear and quick to say, this is what happened. This matter was in court. The judgment come from the court is aware, even the defendant lawyer of the tenants, they are aware the matter, how long it has been happening, because they had the lawyer that were defending the matter. And we believe that it should be just scrapped out the completely amount.
To your statement, we will just mark this as Annexure A, and you then have the following document dated 2023-03-13, City of Johannesburg Public Safety Committee.
Done by the professional people, that they understand what need, how the building need to comply, and what are the requirements for the building to comply, and for the building that is residential for the tenants to able to stay in that property. And in that building, in that inspection report, they also explain the contribution that were identified by fire safety. So they
Yeah.
explain everything, so it's in that report.
Yeah, well, for our purposes, we can just observe that the report was a report It's an official report by the city, the Public Safety Committee, which made observations about the status of the building. The next document,
No, it's a,
that's the one. I think mine has been copied twice. The last document, no, it's also copied twice. Yeah, that would constitute your statement. Am I right?
correct.
Madam Chair, if there is no objection, may the statement together with its annexures be admitted into evidence as annexure, as
A.
exhibit SM1. As exhibit SM1.
The statement is duly admitted as exhibit SM1.
With no questions arising, or for clarification maybe?
Mr. Nyando?
Madam Chair, we have no questions for the witness.
Thank you. Ms. Madumisa?
Thanks, Madam Chair. No questions to the
Mr. Mgomezulu?
Thank you, Chairperson. I have about 2 questions.
Yes, you
Thank
may
you.
proceed.
Thank you, Chairperson. Sir, when did you become involved in the Remington matter?
I've been involved since 2014.
2014. And the owner being Nulane Investment,
Yes, correct.
and that's still the position?
Yes.
That would be the question,
Thank
Mr.
you.
Chairperson. Thank you.
Ms. Tole?
Madam Chair, no questions from the
Thank
Commission.
you. Yes. That being the case, Mr. Ramulamula, we thank you for having availed yourself to give evidence before this commission. You are excused as a witness.
Thank you.
Chair, that is the business of the commission for the day. We'll proceed tomorrow in the formal hearings.
These proceedings are adjourned until tomorrow at 10 o'clock.